to the next problem. Section 109. When a law of a state is inconsistent with the law of the Commonwealth, i.e. you have the Crown in the Commonwealth, but you have the Crown out of the state, you now have a law that's in conflict with the Commonwealth Constitution, which then says the latter shall prevail and the former shall, to the extent of be invalid. All I'm doing is reading your contract to you, because you agreed. Or did you disagree? Because it said at the preamble, you have agreed. So you've inherited the agreement. Now you must defend it, or you'll lose your inheritance. Section 44, subsection 1 of the Constitution states, any person who is, under any acknowledgement of allegiance, obedience or adherence to a foreign power, or as a subject or a citizen, are entitled to the rights or privileges of a subject or a citizen of a foreign power. Section 44, subsection 2, is attainted of treason. Now, there's not a lawyer in this country, judge or lawyer, QC or whatever, that can give you a written legal opinion on what the words attainted of treason mean. Why? Because we've never had a treason trial. So nobody's up to speed on it. Now, in reality, it means accused of treason. Look at the bottom bit. Shall be incapable of being chosen or of sitting as a senator or a member of the House of Reps, which would automatically catch your whole Commonwealth Parliament and your current state parliament. Section 128 is the only way you can legally alter that constitution. They did it another way, they tried it another way, but now they have to go back and see if they did it legally. That's why the title is the Unlawful Government. It says the proposed law for the alteration thereof must be passed by an absolute majority of each House of the Parliament and not less than 2 or more than 6 months after its passage. Through both houses, the proposed law shall be submitted in each state and territory to the electors qualified to vote. That's the only way they can change it. So they're getting changes in the Constitution, state and Commonwealth, that are not coming to the electors. And you don't have to look at much law to see that if it didn't do that, they're saying those laws are invalid. But you've got people representing you on that invalidity. Western Australian Constitution, I'm going to touch those sections. Section 273, Australia Act, Request Act. They're the sections we're going to deal with in this section. Section 2.2. Now, if you used to, before there was the change from Labor to Liberal, when you used to write to the Attorney General, he would reply and say, the Queen is still in the Constitution at Section 2.2, which was a correct answer, because she hadn't been taken out of 2.2, but when you look at Section 2, it has 3 subsections, 1, 2 and 3. Now we'll have a look at Section 3. What Section 3 says. Every bill after its passage through the Legislative Council and Legislative Assembly shall, subject to Section 73. So Section 2 is bound by Section 2 subsection 3 and automatically activates Section 73. You can't get around it any other way unless you're doing it deviously, and they've certainly done that. Be presented to the Governor for assent by or in the name of the Queen, and shall be no effect unless it has been duly assented to by or in the name of the Queen. So Section 2 subsection 3 automatically kicks you back to 73. So the answer of 2.2 is an incorrect answer or an incomplete answer, because it didn't give you Section 2 subsection 3, which then activates 73. Now 73 in your state constitution states that Section 73.2 is the referendum requirement added in 1978, binding 6 clauses or sections to electoral approval. Know those 6 sections because we're going to touch on them. It's Section 2, Section 3, Section 50, Section 51 and 73 and 4. Now this is what 73.2e states. A bill, now see at all times it's only a bill till it conforms with its correctness. Now those words expressly or implicitly are very important legally, because expressly means, well, we can't miss it because it's written, or it implies. Now clearly it's implied an intent to remove the Queen. So section 2.2, the Queen is now at threat by the implication. Expressly or implicitly in any way affects any of the following sections of this Act. Section 2, 3, 4, 50, 51, 73. Shall not be presented for assent by or in the name of the Queen unless the bill has also prior to such presentation been approved by the electors. So that means the elector has to see it before it can get its sign-off. Now I know that West Australians not only never saw it, but don't even know you've got this in there. And it's not up to us to what you call get a rent a crowd. It's only up to us to know what we're doing at a legal bar table. The rest can come along as a rent a crowd. But they've got nothing to do with what happens at the bar table. You're either right or wrong at that bar table. And a bill assented to consequent upon its presentation in contravention of this subsection shall be of no effect as an act. That's in your law, that is your constitution, which is bound to the Commonwealth Constitution under section 106, and the inconsistency or invalidity act under section 109 of the same constitution, which is the superior constitution. Am I winning or losing? Because you're the jury, as I said to them, and you're the witness, Anne. It's out of their hands, it's in jury hands now. Which means this is not a bench judicial decision. This is a jury decision. Anything less than that is attempting to pervert the course of justice. Now here you have the Australia Act Request Act, West Australia. This is what you requested. You did know you did request it, didn't you? Because it says a Request Act. You do know you requested this, don't you?
No.
Well, it says a Request Act.
Well, they're lying.
And it says, whereas the Prime Minister of the Commonwealth and the Premiers of the States at conferences held in Canberra on 24th and 25th of June 1982 and 21st of June 1984 agreed on the taking of certain measures. Well, essentially you got one man and a few cronies sitting at a coffee table agreeing to do something on your behalf. Which is why they call it a Request Act, because they requested it because you requested it. You getting the drift? Agreed on the taking of certain measures to bring constitutional arrangements affecting the Commonwealth and the States into conformity with the status of the Commonwealth of Australia as a sovereign, independent and federal nation. Look at the date, 1985. Remember the date. And where it has been agreed that the Parliament of the Commonwealth, at the request of the Parliaments of the States, did you request that to your Parliament? No. Because it said you did. Now I'm assuming the politicians in the State Parliament actually work for you under the electoral constituency rule. Or I got that wrong. Or did they agree on your behalf to something that they didn't ask your consent for? Or did I get that right?
You got it right.
Now remember, a jury is the elector. So we're talking to people who haven't seen this. We're going to win it real easy on a jury trial. Because they just simply say, we never saw it. So that's why I'm asking you if you saw it, because you represent that jury. Not yet legally impanelled. That's got a bit of doing a bit of the dance at the moment, but at the moment the government is saying we're legal and you guys are wrong. But at the moment they've got to come and disprove all this. They've got a bit of making up to do. And I will say it loud and clear. Where's the preachers of the Christian church in this who says, come to us and we'll give you the truth? Where are they?
Sleeping.
No, they're actually committing an indictable offence by concealing this. That's worse than sleeping. And where it has been agreed that the Parliament of the Commonwealth... hang on. Who agreed? Who owns this Constitution?
The people.
Well, that's what the preamble's about. Which means if you don't agree, don't touch that document. At the request of the Parliaments of the States in pursuance of Section 51, see here they're supposed to go to Section 128. I'll put the bit of that in there, Darren and I. But rather than go to 28, which would have